Mendon.
Thank you, Mr Speaker. Mr Speaker, I rise to support the comments made by my colleague earlier and reiterate the Greens' objection to this bill, our opposition to this bill, and we do so on points of process and indeed of substance. The process issues are clear. We are in urgency. I was handed a paper copy of this bill at about 11 o'clock last night. We did not have an electronic copy. We had no access to the regulatory impact statement. It is very difficult to make substantive decisions, to make judgments on the quality or necessity of a piece of legislation at 11 o'clock in the evening without the benefit of reference to any other people. We had no knowledge of the status of the evidence being talked about. We understand that for a number of years, for a period of some 2 years perhaps, evidence was retained, which was actually an illegal act on the part of the police, an inadvertent one, clearly, something they believed they could legitimately do. It was not until sometime after 8 o'clock this morning, when we were able to get access to one of the Minister's advisors, that we knew about the status of that evidence, what the actual mischief was that this bill was seeking to correct. We were speculating until we saw this bill land on the table an hour and a half ago as to what was the problem that was being addressed here. Certainly our speculations led us to the position that the government is proposing, that there is an issue here of potential liability, but it is a clear failure of process on the government's part not to inform a party in this House of what is actually going on, a process reason in itself sufficient to oppose it. The Standing Orders Committee is currently working on ways of streamlining the work of this House to avoid the necessity for urgency or for extended hours. If all parties in this House are taken into the confidence on matters like this, which is a correction of an error, we concede that. An error was made by everybody in this House. There is no dispute about that. But to the extent that we are not taken into the confidence and given an appropriate period of time to give due consideration to these issues, then the government is going to hit barriers. Any government will hit barriers if we are not given due time. It's interesting to know the Māori Party has had 10 days to consider this, and they've come to a view to oppose it, and we respect that view, as I hope all others do. We do not know how long Labor has had to consider this bill. We have had overnight and less than an hour and a half this morning. We are not in essence opposed to correcting errors. From my memory, we supported the necessary change to the Constable's oath issue last year or earlier this year. There was a clear and urgent need to do that, to make that change under urgency, because it did potentially endanger a significant number of arrests and indeed later convictions. We are now told that the government has been aware of this problem since October 2010. There has been ample time and opportunity to give this issue correct and appropriate process, to engage the whole House in looking for a solution to what the problem is. We are told, I assume in good faith, that nothing in this bill will extend the powers of the police, that it will simply revert to what was believed to be the status quo post the change in 2008. With all due respect to the good intentions of people making those claims, we'd like the opportunity to verify that. It is not unheard of. Errors do occur, either intentionally or by error. This bill could be giving further powers to the police around the issue of evidence, retained, gathered, whatever it might be. We would like to have the time to get an independent legal verification of that point, and clearly that is going to be something that is effectively denied us unless we can do it in the course while this debate is actually in process. The point has been made that the police are seeking to restore what they believed was their authority to retain evidence from young people who are effectively convicted in the youth court. The exception is those who are sent to district court for sentencing. Clearly that is a high order of offending that would involve that reference to the district court. Within the ambit, under the sections 283A to N of the Children Young Persons Act, which is referred to in this bill, there is an extraordinary range of penalties against which young people can be given, and if they are so penalised, then the information can be retained. Under Section 283A, it refers to an instance where a young person might be found to have offended by the youth court, and the judge might choose to discharge them or to issue an admonishment. Basically give them, for want of a better word, a good bollocking in the court, to tell them off, to indicate to them that they may be at the top of a slippery slope, and to encourage them to mend their ways. I suggest that judges would only use that option where the offending was at the very, very low end of the scale, where perhaps the young person had no history of offending, perhaps a good robust family background. We can assume that the judges would exercise their judgment in giving those very, very light-handed penalties. At the other end, under the Group 7 responses, you're talking about much more serious penalties given to that young person. Supervised residential supervision, requirements to pay reparations, to pay quite substantive fines, effectively penalties that would and could routinely otherwise be applied in an adult court, in the district court. Under the substantive part of this conversation, we'd like to challenge whether it's appropriate that, for example, evidence ought to be retained, the youth IP ought to be retained, when the judgment is that the offending was of such a low order that simply a discharge or an admonishment from the judge was an appropriate response from the youth court. That is a very long way from an offence, a single offence, or more likely a history of repeat offending that caused the judge to make a much more substantive to impose a much more substantive penalty along the lines of supervised residential, whatever it might be. We are told that there is a likelihood of costs being involved if this error is not corrected and the correction made retrospective back to 2008. That is a genuine concern. However, looking at the numbers, the figure I think of $6 million pops up at us from the RIS. I would highlight the fact that the possibility of an appeal for a young person who has been convicted would only be there if the evidence previously retained by the police was the sole evidence that led to that conviction. A fingerprint, for example. It would only be in cases where there was no other evidence, where there was no admission of guilt, where there was not some other means of identifying the culprit who's committed whatever the offence may be. So that the number of cases where there is a likelihood of liability to the police, to the Crown, would be very, very small, I would argue. How many cases at the youth court level rest on a single fingerprint, perhaps a single photograph from a CCTV camera? How often is that single piece of evidence not reinforced or supported by somebody who observed a carry-on, a shopkeeper, a member of the community, other evidence being available to the court upon which to base a finding of guilt at the youth court level? It is true that there is, having said that, doubtless there will be occasions where a young person might potentially see the opportunity to appeal. Again, I'd reiterate what my colleague Mr. Locke said earlier. The likelihood of a young person wanting to once again go through the court process, once again shine the light on the fact of their prior offending and that they were actually issued a conviction or the equivalent of a conviction. The likelihood of that, we believe, is vanishingly small and does not justify this urgency process, the secrecy under which this legislation has been brought to the House. We've now been debating this matter for something an hour and a half, an hour and three quarters. The rest of the country is probably completely unaware of what we are doing. And without getting into pedantics, we are actually making a substantive change here. What is currently not legally allowed police practice will become legally allowed police practice if this piece of legislation goes through. So to suggest that it's not a substantive change is actually a little bit ambiguous, to say the least. To bring into the debate the matter of a 1958 piece of legislation, which was amended 2008, we will say more about that in later speeches. Kia ora.
Ko Rahui Kātani.